Thank you very much, and welcome everybody. Welcome to our conference on contract management. In this presentation, we're going to be considering the impact that COVID-19 has had and is having on commercial contracts, and consider some of the contractual and legal mechanisms which come into play where you or your suppliers are prevented or restricted from performing contractual obligations due to coronavirus. I'm Matthew Walton, a partner in the commercial team here at VWV, specialising in working with schools and academies. My colleague Ben Holt, a partner in our dispute resolution team, is co-presenting this first session with me. And Stephanie Rickard, a partner in our procurement and public sector team, will be talking through some of the government guidance, such as the procurement policy notes or PPNs, which are intended to encourage support for public sector supply chains. So, as we start, as you might imagine, we've been dealing with COVID-19 related queries since early February, with questions ranging from school closures, whether partial or full, issues in supply chains where one party is unable to perform due to shortages of labour or lockdown, and challenges faced by concession holders, such as catering contractors, as a result of being unable to access premises. And catering contracts tends to be one of the areas that we've got most involved in. In this presentation, we're going to consider how force majeure provisions typically found in commercial contracts might be able to help, and also how the legal doctrine of frustration may apply in such circumstances. Now, force majeure is something most of us will have looked at and considered over the last few months. The concept of frustration, probably a little bit less familiar. We'll look at some useful pointers for effective contract management where these sorts of issues arise, and we will look at how the government is directing the public sector to behave when dealing with suppliers who are struggling with performance as a result of COVID-19. From the issues we've been advising on over the past few months, we've identified two key themes which crop up time and again with schools we're talking to. The first is that force majeure clauses don't always work in the way that parties assume they will. There's a common assumption that provided you have a force majeure clause in the contract, you're protected against the effects of the force majeure event. And as you'll see, that's not always a perfectly safe assumption. The second key theme is that even where one party to the contract has a clear contractual right and position, we've been seeing an overriding willingness to take a pragmatic and supportive approach in working through the challenges of COVID-19, which affect both sides of the contract. It would be nice to think this is a sign of society pulling together in difficult times, but there's also a heavy dose of reality here. With the challenges faced by business as a result of COVID-19, not taking a pragmatic approach risks pushing suppliers into insolvency. And at the end of the day, that's likely not to be in either party's interests. Schools need contractors ready and able to start performing again as and when schools reopen fully, whenever that may be. And taking this further, the same principle applies when it comes to dealing with changed circumstances and ways of working when schools do reopen fully. For those contracts involving individuals attending school premises, there will be significant changes, such as the extra costs associated with risk assessments, PPE requirements, etc. Again, the terms of the contract will determine who is responsible for such costs, although in the main, it's likely to be contractor's liability. However, is there a way the school and the contractor can work together to ensure these obligations don't prove so onerous as to make the contract unworkable? And in recent government guidance, and Stephanie will be talking more about this and the PPNs later, in the latest government guidance, it does refer to working with your suppliers to develop a transition plan, which should include, and I quote, an assessment of any costs associated with implementing Public Health England guidance specifically in relation to delivering the contract. But of course, it does then go on to say this should be considered on a case-by-case basis. So I'll now hand over to Ben to look at actually what is involved in a force majeure clause. Ben.
Thank you, Matthew. Well, in the absence of anything to the contrary, the starting point, of course, in law is that parties to a contract are required to perform their obligations, even if that's made difficult by some external event. Now, many contracts will include provisions dealing with events outside the party's control, often called force majeure or act of God clauses. Matthew will have a look at the legal concept of frustration shortly, but force majeure is not a thing that applies automatically. It is only relevant if it's expressly included as a clause in the contract. The clauses, they're essentially there to deal with the allocation of risk between the contracting parties. So if one party can't perform its obligations, that would obviously normally be a breach of contract. If the contract contains a force majeure provision, that party may be relieved of any liability as a result. Now, how they operate is dependent entirely upon how they're drafted. They'll only provide protection for an inability to perform obligations if that protection is set out, and it's usually in very carefully defined circumstances. Up until recently, force majeure clauses were very rarely relied upon. We certainly all studied them at university, but to the best of my recollection, I don't recall having advised on force majeure provisions in the nearly 18 years I've been working as a lawyer prior to the past few months. There simply hasn't been a point in my life when we've had such a widespread event beyond the control of contracting parties. I mean, the volcanic ash cloud was a small event that presented some issues, but probably the greatest significance to me wasn't a legal matter, but it prevented Blackburn Rovers from signing Robert Lewandowski. And then he had to go off to Bayern Munich, and he scores virtually a goal a game, and he's won the league 5 times, I think possibly 6 now. So he's obviously kicking himself over that one. But seriously, it's only really the Spanish flu that would really be comparable. And force majeure simply wasn't a mature legal concept back in 1918. So we don't really have any meaningful precedence over what all this means. So let's have a look at what you should look for when considering whether your force majeure clause applies in your particular circumstances. Well, first off, look at the event itself. Is the event covered? Some clauses list a closed category of events which constitute what the force majeure event are, and the event must fall within that list in order for the clause to apply. If COVID-19 isn't capable of being interpreted as within that list, then the analysis might stop there. But even if a pandemic scenario or something similar to that isn't specifically referred to, the consequences may be sort of like maybe the imposition of government restrictions. Now, many force majeure clauses also refer more generically to any event outside the reasonable control of the parties. So if your clause works in that way, lockdown is likely to be an event which is outside of the reasonable control of the parties, and it's therefore likely that it will cover the scope of the force majeure clause. But it's not just enough to show that the event falls within the category of events listed. The clause must also require that the event has had some impact on the performance of the obligations under the agreement. So you'll also need to show how badly affected your obligation needs to be. Some clauses require that you have to have been prevented or even made impossible to perform by the force majeure event. Now, that's a really high bar to reach in many cases. Other contracts may require that performance has just been hindered or delayed as a result, clearly a much lower bar. You also need to consider which obligations have been affected. It won't be all of them necessarily. And unless your particular force majeure clause is to suspend all obligations of both parties under the agreement, which I don't think I've seen a single contract that says that yet, the parties will only be relieved of their responsibility for those obligations which have been prevented or hindered by the force majeure event. Matthew.
Thank you, Ben. So what are some of the other typical features of a force majeure clause that you might find in your contract? The first and an often overlooked one is the requirement to notify the other party of the force majeure event, setting out the consequences of the event and how performance will be affected. Now, the fact that schools were closed by the government may well have been clear and obvious, and you may feel as though there was no need to notify anyone. But if the contract includes such a clause, you would still have needed to formally notify your contractor. And timing is key here. Usually, contracts require notice to be served within a set period of time. And if you delay and miss the boat, it could prevent you relying on the force majeure provisions and protections. However, there could be good reasons, tactful reasons even, for delaying service of a notice if you're in good faith discussions with the supplier. The important thing either way is to get the contract out, check the notice clauses, review the provisions so you can make an informed decision. You should also check the notice and the service of notice provisions within a contract, especially if the force majeure clause refers to notice being given. Often that is defined and terms set out in the contract as to how that would work. There are formalities that will need to be complied with. So will the email that your colleague sent to his contact be sufficient? Possibly not. Suspension of obligations. When a notice of force majeure is served, what are the consequences? It will invariably act to suspend the obligations of the party affected by the force majeure clause. But as Ben said, how will it deal with the other party's obligations? Some contracts, not many, will suspend all obligations, some only those affected by the force majeure clause. So again, check the specific drafting. Force majeure clause will often provide an option to terminate if the force majeure event continues to prevent performance for more than a specified period of time, or it's likely or it will be that the force majeure event will continue for a period of time in the future. One or more of the parties can then have a right to terminate the contract. Typically, the clock starts ticking when the notice of force majeure is served, but suffice to say, you ought to be very careful before exercising this right. Getting it wrong can be a costly mistake, and we'll come back to that and talk more on that later. And finally, is there an obligation to mitigate the effects of the force majeure event? Perhaps surprisingly, the law doesn't always impose an obligation on parties to minimise losses, though there can be consequences if they don't and then seek to recover full losses. However, a clear contractual provision removes all doubt. And once again, and this may be a fairly common theme as we run through this, check the contract and see what the specific drafting says. So that's a brief whistle-stop look at force majeure. And now what I'd like to have a look at is the legal concept and the legal doctrine of frustration. If you open your contract and find there is no force majeure clause in there, as Ben said, without a force majeure clause in there, there is no terms giving you that relief. So you may want to consider whether your contract runs the risk of being frustrated. Now, the doctrine of frustration is a concept that's been developed by the courts, which allows a contract to be discharged where an unforeseen event occurs, and we'll come back to how important the unforeseen event issue is, which renders the performance of the contract impossible, or which radically changes the obligations of the parties. And as I said, unlike force majeure, which is only available if it's included, frustration exists in common law, so it doesn't need to be included within the contract. Now, the background, the purpose of frustration is to avoid injustice where there's been a significant change of circumstance and neither party is at fault for the change. You can see the link to force majeure there. However, the threshold for frustration is very high. The test is strict and the courts apply it narrowly. And there are broadly three types of frustrating events. First, where performance of the contract has become impossible. Second, where the agreed purpose of the contract has become impossible. And finally, where there is a significant change to a mutually agreed state of affairs. Now, one of the very few positives to have come out of lockdown is that we haven't had to hear arguments about Brexit on every news bulletin. So I apologise for using the B word here, but a great example of how difficult it can be to demonstrate frustration is the relatively recent Brexit frustration case. In this scenario, the European Medicines Agency sought to argue that its lease of office space at Canary Wharf in London had been frustrated, and the lease had therefore come to an end. Why did they say it had been frustrated? Well, because of Brexit, it means that the EMA can no longer be based in the UK. The agreed purpose of the contract, they said, was no longer possible because this EU law required them to relocate out of the UK into the EU. Now, whatever your views on the merits or not of Brexit, that doesn't sound like an unreasonable position. But I told you it's a difficult test to meet, and the courts disagreed with the European Medicines Agency and refused to allow them to walk away from their new lease. So if you demonstrate frustration, moving on to what are the consequences of frustration. And if you're able to demonstrate that the contract has been frustrated, what are the consequences? A force majeure event usually results in the defaulting party being relieved of its liability, and it only results in being terminated if the event continues for a long time. However, in the case of frustration, the contract is automatically discharged and all present and future obligations are immediately extinguished. If money has been paid in advance, it may be deemed repayable, and conversely, monies already incurred, such as expenses or fees, would need to be covered. But of course, this is a profound consequence and a further reason why frustration is made so difficult to use. So could school closures fall into one of the three types of frustrating event? It's possible, for example, if performance of the contract has become impossible, though of course most schools didn't fully close and remained open for key workers. However, given the consequences, would this be an appropriate course of action? Terminating a contract for being frustrated would, of course, mean there's no contractor there to pick up the pieces and start again as and when the schools reopen. It's also important to note that, as we said at the outset, frustration only applies if an event is unforeseen. And while you could certainly make an argument that it wasn't foreseeable that schools would be forced to close for several months due to COVID-19, now that that's happened, it would be difficult to argue that a future pandemic lockdown was unforeseeable. So that's really the first look at frustration. And in terms of practicalities, I'll now hand over to Ben. Thank you, Matthew.
So basically looking at some ways in which you can minimise the risks of disputes arising out of this. As I mentioned earlier, I think the majority of our clients and the counterparts are looking at pragmatic ways to deal with issues, which is always sensible. And as a litigator, I can certainly assure you that you really should only be looking to get into a formal dispute as a last resort. It's almost always better to find an amicable negotiated solution. Litigation is tremendously expensive and time consuming. And it is usually the case that the only people that really win from litigation are the lawyers. You almost never recover all of the costs you've incurred, even if you have an emphatic victory. So some form of compromise is almost always sensible. And the vast majority of disputes do settle. Almost everything that comes across my desk could, in theory, go to some sort of trial or tribunal. And it's now over 15 years since I've had a fully contested trial that has gone all the way. So statistically, there's usually always a deal to be done, and it shouldn't go that far, but it could. I think the first thing to say is bear in mind that just because the contract says that things should be dealt with in a certain way doesn't mean to say that they have to be. The parties are almost always free to vary the contract. And certainly with a change of circumstance like we've seen here, whether or not your force majeure provision provides for it, there's nothing stopping you changing how you're going to deal things going forward. Now, it's always obviously sensible, even if you're going to try and avoid a dispute, to have an understanding of the strength of your position to help with your bargaining, even before you enter into negotiations, and also to be considering ways of minimising the risks if a solution can't be found. So by now, I mean, hopefully probably by about a month or so, it should have been fairly apparent if any contracts that you've got are likely to be affected by coronavirus. So first thing to do, it sounds obvious, but pull out the contract and carefully consider what it actually says and which provisions apply. It's amazing how often people don't look at a contract after they're signed, or indeed even at the point of signing. And I'm certainly not practicing what I preach here, because I don't know how many times I've ticked yes to things like the iTunes terms and conditions when those get updated, and I don't read the 120 pages on my iPhone, funnily enough. But if the contract does require you to make efforts to avoid non-performance, make those efforts. Failure to do so may make any protection under a force majeure provision invalid. Potentially look to agree what those steps are going to be with your counterparts. It's going to be harder for them to argue that those steps weren't sufficient at a later date if they agree with them now. And it'll also be helpful to create a paper trail of what you're going to be doing differently. And if there's change control provisions in the contract that have a process by which they have to be done, follow those processes. It sounds obvious, but look for ways to minimise your loss. There's several reasons. You're going to need to deal with the impact of those losses until you win, assuming, of course, you do win. If the party that you're contracting with, if they successfully operate a force majeure provision, their non-performance will not be a breach, and therefore they will not be liable for your losses suffered as a result of that. And finally, even if they are liable, both the contract and the common law may require you to take steps to mitigate or minimise any losses that you've suffered. Now, as mentioned, both force majeure and frustration can result in the contract being terminated. This is something that you need to be super careful about. It's probably one of the most common issues that we speak to schools about on contractual issues in terms of getting termination wrong. If you terminate a contract in circumstances where you're not permitted to do so, that can amount to what's known as a repudiatory breach, a breach showing that you have no intention of continuing to be bound by the contract. Now, if you're not allowed to do it, it'll be open to the other side to terminate the contract and sue for breach themselves, as in your unlawful termination is a breach in itself. And they don't have to fulfill their own obligations, and it could create a liability on you for the whole remaining value of the contract. We quite often see this with things like cleaning contracts or catering contracts, where it will be the caterer or the cleaning supplier who provides their standard terms to the school. They won't be on the sensible terms that I'm sure you've all got our standard terms in place for bigger contracts, but for smaller things, there will be terms that just don't really work for schools. They might have really very difficult termination provisions saying, effectively giving you half an hour on a Tuesday in 7.5 months time to terminate, otherwise it rolls on forever. And that's, I'm slightly joking, but they're not that far off on some of them. So be really, really careful about terminating. But also, it's really important not to delay on termination, because if you do, you could be waiving any right that you do have to terminate. If you're going to terminate, it also usually requires formal notice to be given. So as we said before, check the notice provisions. And quite often people will assume, as Matthew was saying, that I've sent an email saying we're terminating, that's good enough. Often it's not. And quite often that's the point where your counterpart will go, haha, well, you haven't provided notice in the correct form, even though they clearly knew that you were wanting to terminate. It's not good enough, and now you can't, and now now your opportunity is only to do so in 1 year's time because you've just missed it. So just be very careful on termination. You should also check for any time limits in the contract, such as whether the force majeure trigger has already happened, or is performance already affected, or is it just the case that it might be in a month or so's time? For instance, if you were planning to rent out your school premises or part of them in August, are you currently prevented from doing that? It might depend upon what the event is, where your premises are, how big they are, what the event was going to be. But quite possibly, they're not technically prevented from doing that just at the minute. It's only, we'll have to wait and see. So you might end up in a game of chicken with your counterpart in terms of who's going to can it first. The sensible thing is obviously to have a discussion about it and agree what you're going to do. If your opponent is threatening to pull the plug, and you believe that they can't do that, let's say somebody was wanting to use your premises for the October half term, for instance, there may well not be any reason why they can't do that, and you believe that they can't do it, you might need to consider whether you need to seek an urgent injunction from the court requiring them to continue performing. For instance, if a cleaning provider is saying we can't do it and we're not going to for coronavirus reasons, if you need them to continue performing, an injunction may be necessary. Think very, very carefully indeed before going down that route. It's very expensive and injunctions are really difficult to get, but in certain circumstances it might be your only option. Probably something more like an IT supplier with critical systems is more likely to be relevant, because you should be able to get in alternative cleaning suppliers for less money than an injunction would cost. But if you did need to make an injunction application, they need to be made without delay. It's one of the grounds that the court would look at in determining whether or not to grant the order sought, but they should be very, very rare that you ever think about going down that alleyway. And clearly a key factor in deciding how you're going to proceed is working out how much the issue is worth, both financially and reputationally. The aim's obviously got to be to find a solution that's going to cause the least overall damage, and legal cost and publicity should be factored into that picture. Coordinate responses across your organisation. That'll help you identify, manage and mitigate risks, but it's particularly important to avoid mixed messages, particularly to third parties. And I'm sure a lot of you will be aware that the press like to have a pop at schools, so managing your comms is very, very helpful. And obviously lots of angry parents going on social media saying bad things about the school is also very, very common. So let's make sure that we don't have somebody in one of the teams deciding to respond to those without having a coordinated response. It's also important to consider your insurance policies, particularly things like business interruption, event cancellation, liability and legal expenses cover. If they kick in, the requirement is usually to notify your insurer when you become aware of circumstances that could give rise to a claim. And straight away at that point. I'm seeing a lot of insurers seeking to avoid cover for COVID-19 issues at present. That's for another talk, but it's a really complicated area, and you shouldn't necessarily accept your insurer's first response on this. This one's a bit of a watch this space. The FCA are fast tracking a case that's going into the courts next month to try and determine the meaning of some standard insurance clauses. So hopefully we'll have a clearer picture in about a month or so's time. But also bear in mind that your insurer might take some time to confirm the coverage position. So unless and until it's confirmed, you should act as a reasonably prudent uninsured. Basically, don't do anything daft. Nothing that will prejudice the insurer's position. Don't start making offers without their sign off on them. And it's also likely to be the case that any costs you incur before the insurer gives the go ahead won't be covered. So I'll just hand it back over to Matthew for a short summary conclusion. Thank you.
Thanks, Ben. Always very helpful to get some real practicality advice and suggestions and thoughts. So that's just about it from this first session. Before we wrap up and hand over to Stephanie, though, I'd say 3 key takeaway points from Ben and me. The first is force majeure is just another contractual term. The extent to which you can benefit from its protection will depend entirely on what the contract says and how the clause is drafted. And certainly over the last 3 months, I've seen everything from a 1.5-line force majeure clause through to a 2-page force majeure clause. So the key thing is to get that contract out, read it, and understand what it says. Frustration is there in the background. It's a common law right that is always potentially available, and it can step in where a contract has become genuinely impossible to perform. But the circumstances where it kicks in are limited. It's very hard to prove, and the consequences, bringing the agreement to an immediate and grinding halt, are going to be profound. We expect in reality this right is going to be used very rarely. And finally, whatever the strict contractual provisions, a cooperative, pragmatic approach when dealing with suppliers is likely to be the preferable route, certainly in the early stages of discussion. Yes, there are things you should be doing to make sure you understand your position and to protect it as best you can, but finding a way to work through these challenges in a way which allows you and the contractor to emerge from lockdown on a sound footing, ready to proceed, ready to look forward to the future, seems to us to be the right priority. So that's it from myself and Ben. And now hand over to Stephanie to talk about public procurement notices. Stephanie.
Looks like Stephanie's just having an issue loading up her screen, so we'll just give it a minute.
Should I just pick up I see we've had a question from Karen on the fact that many schools have RPA cover rather than commercial insurance. So I'll just pick that up while Stephanie's re-logging in, if that's all right. We do certainly come across this a lot. I think most of our academy clients tend to have RPA cover rather than external, normal commercial insurance. I think essentially I would treat it in much the same way as you would treat any other insurer. Notify them of the circumstances. Get on with it as quickly as possible. But the RPA are very keen to point out that it's not, they don't consider it to be caught by various insurance regulations. I haven't quite got to the bottom of this yet, but that relates to the ability to select your own legal advisor. But on the whole, they do tend to be fairly sensible, and I think the safest bet is to treat them in the same way as a normal insurance provider. We're not going to be any clearer on the actual specific terms for the RPA, probably for some time afterwards, unless they exactly mirror the terms of Zurich and the likes, because we haven't got any clarity from the courts yet until next month on the normal commercial insurance. But I'd basically treat the RPA in the same way as a normal insurer, and keep them informed, let them know what's going on. You will likely have cover for claims being brought against you, possibly less so in respect to any claims that you may need to bring yourself. But hopefully that helps a little bit.
Great, thank you, Ben. We're still just waiting on Stephanie to hopefully be able to rejoin us. Not sure what's happened now. I think it might just be a connectivity thing. So we'll just give it another minute or so and see if Stephanie can get back in with us. If anyone has any other questions in the meantime, feel free to pop them in the box, and I'm sure Matthew and Ben will be happy to help with those.
This would be great timing for a question. I think in the absence of any asked questions, one of the most common issues that we get to advise on and have been advising on at this moment is in relation to catering contracts. And catering contracts are one of those contracts which have been primarily the focus because it's one of the greatest potential areas of expenditure within schools. And what we've seen is a great, and without wishing to cut over what Stephanie's going to talk about, the public policy notices, the procurement policy notes even, have been talking a lot, and contractors have been relying on those and coming to schools saying, you know, we'd like you to take over provision for these contracts. We'd like you to change your financial mechanisms. And often these contracts are what we call concession contracts. They're contracts in which the schools do not actually pay for the services themselves. They simply allow the contractors the opportunity in the window to sell these meals to the pupils. So a lot of what the procurement policy notes say may not be entirely relevant to these clauses. And we've had a situation where several catering contractors have not taken advantage or purported to not be able to take advantage of the furloughing rules. So it is something that's hugely important. It's something we've done a lot of work with. And again, if there are any questions, we'd be very happy to answer those. But I see Stephanie's back online, so I'll take this as the opportunity to hand back to Stephanie. Thank you.
Great. Stephanie, just to say, the presentation's just gone back to the beginning, so you'll need to just flick back through to your slides, okay?
Okay, brilliant. Hopefully everybody can hear me now. I'm not quite sure what happened then, because I looked as if I was all joined up, but I gather there was a blip somewhere. Right, I'll start again, and hopefully the connection will hold. So the purpose of this session is to update you on the government guidance on supplier relief. As Matthew mentioned earlier, we received lots of queries from schools and suppliers alike about how the public procurement notices work. So the purpose of the session today is to talk about Procurement Policy Notes 220 and 420, which has recently been issued, which talk about the rules for supplier relief, to provide guidance on how they work in practice and steps that you should take as schools. So as I mentioned, there are two procurement policy notices. Procurement Policy Note 220, in brief, it requires organisations which are subject to the procurement rules, including academies and maintained schools, to identify key suppliers and to put in place measures to ensure continued payment, notwithstanding disruptions to performance. Now, there's a great deal of guidance on the Cabinet Office website. If you haven't looked at the website, I urge you to do that, because there's a lot of guidance, particularly the model interim payment terms, which is the forms that you use to implement any changes, and some facts. Then Procurement Policy Note 420, I updated this slide last week, and since then, we've had further guidance issued by the Cabinet Office on the 25th of June, which is specific to schools. So that's additional sector guidance for schools to have a look at, which provides some guidance about how to operate Procurement Policy 420, which is some rules on how to transition from the supplier relief provisions. As I say, they're regularly being updated, so I check back at least once every couple of weeks. Now, one of the frequent questions that we're being asked is whether or not the procurement PPNs are binding. Now, this is an interesting question, and we're getting different views from different people. So, for example, we recently went and got leading counsel's opinion on this in relation to a supplier who was trying to persuade a government authority to apply PPN. And the opinion that we got was that actually everybody should have regard to the guidance. It is non-statutory guidance, but you have to have regard to it. You must decide whether or not to apply it. And if you're not going to apply it, then must be a reasonable justification for doing it. So you can't simply say, we're not going to apply it at all. If you're going to apply it, you have to actually follow the guidance. Interestingly, in the recent update from the Department for Education, they're slating a slightly different approach. They're saying that it's advisory only. But I think that if you go back to the whole purpose of the PPN, which is to ensure that you have a continuation of suppliers when we get back to some kind of normality, I think the pragmatic approach is to see where you can apply it to ensure that there is continued provision of key essential services. The remedies for compliance, this goes back to whether or not it's binding. There are certain remedies that some people can take, for example, judicial review, but obviously that's very expensive and time consuming. But there's also a right to complain via the Public Procurement Review Service. Now, I want to just go through the basic principles in my next slide on what is covered by PPN 220. It's important that we set out the rules and the basic principles of 220 so that you can then see how PPN 420 continues. So PPN 220 applies until, as you'll see, the slide applies to the end of June. So today is the last day that it applies, and as from the 1st of July, tomorrow, then 420 will take effect. So it covers goods, services, and minor works contracts. There is a separate regime for construction contracts. So anybody in schools who's got a big contract going on, there is slightly different guidance for you there. But essentially, there's a number of steps that you as schools need to take. You need to look to see or look to identify those essential contracts. You need to work out that your suppliers are at risk. Now, the guidance says you don't have to wait for suppliers to come and say they're at risk. You have to take a wide definition of whether a supplier is likely to be at risk. And then you have to do two things. You have to pay suppliers as quickly as possible. And then you have to have a discussion with suppliers as putting in place interim arrangements to help with their cash flow. Now, it's that bit of the provision that's caused real difficulties in interpretation. So I'm going to come back to that in a minute. But not all contracts are covered. And this is where we've been having lots of queries, particularly from catering or in relation to catering contracts. So the whole purpose of the PPN is to provide continuity of payment for those suppliers who are reliant on public sector income. But where you've got concession contracts where the supplier is taking the risk of how much income it's going to get in, where there's no volume commitment, then arguably PPN shouldn't be used to support those types of contracts. And also, it means there's a lot of suppliers who are having the opportunity to rely on other measures. And therefore, where suppliers are using the furlough provisions and unable to continue supply, then PPN 220 doesn't apply. Can I just check that whether Matthew, can you wave your hand on the screen? Is the internet connection still holding up? Perfect. Good. Thank you very much. So there may be a number of school contracts where actually the school is not directly involved. For example, transport provisions or after-school clubs where actually the contract is between the provider and the parent. And in those circumstances, the school has no requirement to step in and help with the suppliers. Equally, where the school is perhaps getting grants, then that doesn't apply. But I mentioned we're going to talk now about the difficulty of how do you calculate interim relief if you decide that you have got a key contract where you do need to support the supplier. Right, so the general principle is that if you're making regular payments, you look to see the last 3 months to calculate those payments going forward. But it may be actually that you have got a contract which is payment is at the end of the contract, and there may be problems with supply, and therefore actually there's a big gap for the suppliers. And in those cases, it may be appropriate to think of alternative methods of payments, for example, to look to see whether you can change the milestones for payment, or maybe to make an advanced payment. Or sometimes what we've seen with a number of schools is where there are contracts for catering that actually the schools have said, well, we're going to offer to continue to pay for those meals that you're obliged to provide in terms of infant school meals and provision, but we also might help look towards contributing towards some of the costs that you haven't been able to cover elsewhere. But it is important that you have a reconciliation of payments at the end of the period to make sure that where advance payments are being made, that those are clawed back. Which brings us nicely into the 420, which talks about recovery and transition. So essentially it builds upon PPN 220, it covers the same scope. So it requires you to do a number of things. If you haven't already identified at-risk suppliers, then you should take that initiative. And you should consider whether or not it is right to carry on making interim payments to suppliers. And you should look to see about the process. You'd have a discussion with suppliers about winding down those processes so that you can get back to normality as soon as possible. Hopefully there's a clearer path for schools, because the intention is that everybody's going to go back to school in September. Now, the additional guidance that was issued in relation to schools mentions that if you have made advance payments, then you should set out a process for reconciling those costs. It also talks about the fact that schools are having additional costs due to having to implement health and safety guidance by Public Health England, and it may be appropriate to discuss how the burden of cost should be shared between you and the suppliers. And interestingly, all the sort of stuff about PPN 420 about having discussions in partnership is all very sort of fluffy, but it then talks about actually looking at the long-term sustainability of the contract and having a discussion as to whether it's still viable as a result of coronavirus, and if not, proposals to vary or terminate the contract. Now, both Matthew and Ben have talked about termination contracts and the pitfalls of that, but I think there are some procurement implications as well. So I think if you are going to think about termination, that needs to be considered very, very carefully. But there are likely, in addition to thinking about payment profiles, you likely want to make a number of operational changes to the contract. And so it's likely that you're going to be wanting to make a number of contract modifications, particularly in relation to performance indicators and service level credits, where these will need to be adjusted to reflect the reality of the situation. Now, we're aware that there may be contracts, particularly outsourcing contracts, where suppliers have entered into quite a lot of initial capital expenditure, which they get back over the life of the contract. And it may be that you want to think about extending the term of the contract so you can recoup that initial expenditure. To think about is that your procurement teams will obviously have been under a huge amount of pressure over the last few months in getting all the PPE and all the additional things that are needed. But there will still be the day-to-day contracts which keep coming up for renewal, and it may not be practical, you may not have the resources to carry out new procurement processes for contracts, and therefore there may be a requirement to extend contracts to give you a bit more time to actually carry out the procurement process. I just wanted to flag up that you just need to think at the back of your mind about the procurement rules. If you make a significant change to a contract after it has been tendered, then there is a risk that it could be treated as being unlawful, and that's one of the consequences for contract ineffectiveness. And changing the scope or the term of the contract is often one of those trigger events. Now, luckily, there are a number of grounds under the procurement rules where changes can be made in certain circumstances. For example, where you need additional works or services and they weren't thought about at the time of entering into the contract, or specifically COVID related, where the contract variation is due to unforeseen events. There are some thresholds that apply, so you cannot extend the contract beyond 50% of the value. And in addition, changes must be linked to and proportionate to the event that is given rise to the need to change. So just really a flag to have in your back of your mind about always check that what you're doing is in accordance with the procurement rules. So I just wanted to finish on a couple of key points. Hopefully you have already been in discussions with the suppliers, but if you haven't had discussions, or you need to start thinking about how you're going to wind down any additional support, now's the time to do it. And it's also time to reflect upon the contract and see what do you need to do in the short term to get it to work for you, but actually, is it working longer term? And are there things that you need to do and have a discussion with the supplier about whether it's representing best value over the long term. Really importantly, you'd expect me to say this as a lawyer, please make sure you record your agreement by way of a contract variation. I referred earlier to the model template form, which can be used, or to use the mechanism in your existing contract. Now, hopefully we've got 10 minutes for questions and answers, and I've seen that there's quite a lot of questions coming through the chat, so we'll take a look at those and hopefully answer as many as we can.
Brilliant. Yes, thank you. We'll just wait for Ben to come back, and then we'll get through some of the questions and do a Q&A up until the hours. So I will just come back to the top, and as I say, we'll get through as many as we can. So, common with many schools under catering contracts, schools and academies pay a management fee within the contract. Under the contract and COVID-19, can we expect this request not to be applied? Matthew, you're on mute.
I said at the start it was trying to focus on, so perhaps not surprising it happened. Yes, not surprising that that catering contracts have come up in the questions, and I think this links with a couple of the other questions here as well. One of the biggest issues about the procurement policy notes and the provisions that the caterers rely on and talk about and so on is about continuing or the public sector being expected to continue to make payments where services aren't being provided. And indeed, this is further evidenced by the fact that schools and academies tend to have had confirmation that their funding will remain in place, and therefore the idea is that this funding should continue to pay the suppliers because it's something that the academy has already budgeted for. One of the parts that is very frequently overlooked when suppliers and contractors are referring to PPNs is the business in there about it being on an open book basis. And specifically, the references to the fact that profit should not be made where services are not being provided. So where we consider management fees within the contract, there's a question to be asked there whether that is fees that are there to pay an individual to manage the contract, or whether in a significant proportion of contracts, the management fee is essentially the profit margin. Where there is a profit margin provision within the contract, that should not be payable if the contract services are not being provided. Where there is a management fee because an individual is employed to be managing that contract and that individual cannot or is not furloughed, then it could be that that is a reasonable request for payment to do that. But again, it comes back to this business about being on an open book basis, and Stephanie talked about reconciliation. For anyone that is being asked to make payments or whatever, the first issue or the first response should be to ask to see on an open book basis the data that's underpinning those costs that are being asked for.
Brilliant. I think you've actually just answered the next question I was going to do as well, so I'll move ahead on to the next one. So our caterers are issuing invoices based on the average of meal costs over the 3 months before lockdown, rather than just the cost of free school meals and universal free school meals. They're then wanting to reconcile these costs against further invoices for ongoing costs, such as 20% off their staff salaries, sundries, management fee, and more. We did not have them in school between lockdown and the 1st of June. So are their invoices reasonable?
$1 million question. I think just picking up again, it's on an open book basis. The government guidance about school, there is specific guidance about school meal contracts, and it does talk about free school meal payments being made on the basis of the previous 3 months. Now, we can argue about this based on the fact that, does summer term meal costs equate to the previous term or to the previous summer term a year ago? But essentially, that is the guidance does talk about looking at the previous 3 months. But again, it comes back to seeing the open book data and confusing it with things such as the 20%, which I presume refers to the 20% top up for staff salaries who are being essentially furloughed and covered in furlough for 80%. That 20% uplift is something, again, that we've had an awful lot of questions about. At the end of the day, it is an entirely voluntary decision to upgrade from 80% to 100%. It is entirely the decision of the caterer, but they will invariably put that back onto the schools or to the academy trust and to say, we think our staff are worth 100% of their salary, we'd like you to pay an extra 20%. And that's something we've seen a wide variety of schools and trusts taking different opinions on. Some say no, some say yes to 20%, some say a variety in between, and they tend to take that position based on their pragmatic approach of what will work best in the longer term. But in terms of reconciling these costs, yes, that sounds good. It's the right sort of language. But do make sure that you actually check the financial data behind that, and don't just take their word for it that magically these costs reconcile out and everything that we've wanted has been covered. And in relation to management fee, again, as per the previous answer, do make sure that there's no profit included where services haven't been provided.
Great answer, thank you. Okay, on to the next one. So, question: using agency staff for a one-to-one role for a child with a recruitment company, normal terms would be to provide 1 day notice period. So would this still have been the case when schools close? Anybody got an answer for that one?
Well, I mean, it's a question, I suppose, as to whether or not the supplier relief provisions apply, but it seems to me that actually for agency staff, that there's an argument that actually the PPN is not applicable. So if you're not requiring them, then you shouldn't have to pay.
I think that's right. We've seen this with temporary staff and with recruitment agency staff. And it may well be that there is a short notice period involved, but if you have budgeted for the use of an individual for the summer term, and that has been part of your budget and your setting of the budget and an expectation that you would use that individual for that term, the fact that technically they could have 1 day notice period, we're seeing an expectation that because you had budgeted for it, because that would be covered out of public funds that you are still getting, you would continue to pay for that. But that is very different to the case that you would expect over the course of the summer term to have called on X amount of supply teachers, but only when they were needed and without any foresight as to when that would be. In that situation, you wouldn't be expected to pay because that was uncertain, unforeseeable, and a specific budgeting hadn't been made against that.
Brilliant, thank you. I'm conscious of the time. We did have some technical issues in the middle, so I'll do a couple more questions before we wrap up. So our catering supplier stopped supplying universal free school meals on lockdown. We were left to source another supplier. We have had an invoice from the alternative supplier plus an invoice from the caterer. I asked for the cost of the alternative supplier to be deducted from their invoice. This was refused, and I was told to claim back from the government. Is this right? Quite a long one, so you might want to quickly scan over it yourselves as well.
I think, again, this is the question is, what was the relationship with the supplier? Were they able to supply? Did they decide not to? If they weren't supplying when they were asked to, and they have no costs as a result of that, then what is it that they're claiming for? Is this essentially pure profit, which they think they can get from having furloughed staff, not having paid for the food itself, not having paid the staff, not having to pay overheads, and therefore taking in this money as pure profit? Again, the first thing I'd be thinking about there is to get the supplier that didn't supply the meals to explain exactly what the basis is for those costs. Clearly, you have a responsibility to the alternative supplier, but I would be looking to challenge the incumbent supplier as to what they are entitled to and why they think they're entitled to that.
Possibly a follow-on point from this, and it's an issue that comes up quite a lot, is whether or not the contract that you're talking about is and I'll possibly ask a question for Stephanie on this one, but in terms of a contract that is for a set amount, or whether it's a supply and demand-based contract, and those that are, there is no guaranteed minimum quantities on them, I think are treated quite differently from those that have a guaranteed minimum amount. Stephanie, do you want to add any thoughts on that point?
Well, I think I think that's right. It goes back to the bit about the whole purpose is that if you're relying on a certain income, then that's where PPN 220 steps in. But actually, it's much easier to go back and say, well, you're not reliant on this. It was that wasn't the nature of the relationship. Then I think that's a much easier argument to make. I'm conscious that we're short of time. There's a question here about PPN and the PFI contracts. There is some specific guidance about PFI contracts, so it's worth having a look at that, because that might help with that particular query.
Okay.
I've just got one point that I think that's worth flagging as a quick wrap-up point in terms of any new contracts that you might be looking to enter into. If you're entering into a new contract, you know that there is a good chance that there will be a further lockdown at some point, whether it's in 6 months, whether it's in 12 months' time. On that basis, I don't think any of us can realistically argue that a further lockdown is unforeseeable. And if it's not unforeseeable, frustration will not apply. So it's really important for any new contracts to have specific provisions in covering that. And I probably wouldn't just rely upon bog standard force majeure provisions. Cover what is actually going to happen with your caterer, with your cleaner, whoever it's going to be. If in 12 months' time there's another lockdown, have bespoke provisions in about it, because it's reasonably likely to happen, and frustration won't work. You'll be reliant on force majeure. You might as well all be sensible about it and agree it now.
I would certainly support that, and equally I would talk about now looking at school catering contracts and looking to differentiate between unexpected closures for 1 or 2 days, sort of snow days as an example, and lockdown where we're looking at a significant period of time. And we've seen contracts which contain terms relating to snow day, which were clearly drafted on the basis of snow days, such as paying a proportion of what a contractor's takings would have been in the previous day. That simply doesn't work and doesn't apply if we're looking at 1 month, 2 months, 3 month closures, which is clearly something that wasn't intended when they drafted that. But the results can be unfortunate.
Brilliant. If that's everything you want to say on that, I think we're going to have to draw a line there. So thank you ever so much to our speakers, Matthew, Ben and Stephanie, and thank you everybody for joining. Hope you found the session useful. Sorry we didn't quite get through all of the questions, but I'm sure if you have any queries, then we'll be happy for you to get in touch. And if you do want details of any of our upcoming webinars, then they're all on our website. So thank you again, everybody. Have a great day.